The Supreme Court of Nigeria broke its own oath and buried the African Charter on Nnamdi Kanu's case. Lawyer. A legal practitioner, Onyedikachi Ifedi, has stated that the ongoing trial of the Biafra Nation activist, Mazi Nnamdi Kanu, on terrorism charges constitutes a violation of the African Charter on Human and People's Rights. Nnamdi Kanu's trial is being conducted at the Federal High Court in Abuja by the federal government following his extraordinary rendition from Kenya. Nevertheless, the lawyer contended that the African Charter on Human and People's Rights clearly forbids extraordinary rendition and inhumane treatment as experienced by Kanu during the federal government's abduction in Kenya. He argued that since the African Charter prohibits extraordinary rendition and is incorporated into Nigerian law, the prosecution of Kanu has become invalid and unnecessary due to the circumstances of the abduction. He asserted that permitting a prosecution marred by kidnapping and torture to advance against the Biafran leader is explicitly prohibited by the Charter and upheld by the broader constitutional bench of the Supreme Court of Nigeria. The legal practitioner made his position known in a statement he issued to the media. He submitted that the December 15, 2023 judgment of the Supreme Court by a 5-man panel being used to prosecute Kanu was a great error because a 7-man panel of the same court had in the past frowned at such a situation when extraordinary rendition is involved. According to him, the African Charter on Human, People's Rights prohibited extraordinary rendition as done to Kanu by the federal government, and that since the African Charter is part of the Nigerian law, the trial of Kanu for whatever reason is automatically forbidden. Faulting the December 2023 Apex Court verdict, the lawyer noted that, in one breath, the verdict stripped Mazi Nnamdi Kanu of every protection guaranteed under the African Charter on Human and People's Rights, protections enshrined in Nigerian law by the African Charter, Ratification and Enforcement Act. In another breath, the same judgment is purported to remit Kanu for trial on repealed charges. This was not merely a miscarriage of justice, it was a judicial mutiny against the Constitution, the African Charter, and binding precedent. This is not a mere error, it is per incuriam, delivered in ignorance of binding law, and thus a legal nullity. He cited Supreme Court of Nigeria in a matter between General Sani Abacha and Ors versus Chief Gani Fawehinmi, 2000, 6 NWLR, Pinter 660, 228, where a full constitutional panel of 7 justices of the Supreme Court spoke on the status of African Charter, Ratification and Enforcement Act. He submitted that the Supreme Court in the matter of Abacha and Gani Fawehinmi made it clear that the African Charter is enforceable in Nigerian courts as domestic law. According to him, the Supreme Court made it clear that the African Charter is on the same pedestal as Chapter 4 of the 1999 Constitution in guaranteeing fundamental rights, and that any Nigerian law, policy, or act of the state inconsistent with the Charter's provisions is void. According to him, this decision is binding law. Under the doctrine of stare decisis, a smaller panel of the Supreme Court is bound by it. Only an equal or larger panel can depart from it. In Osho versus Foreign Finance Corporation, 1991, 4 NWLR, Pit 184, 157 at 188, a smaller panel is bound by the decision of a larger panel. Oladokan v's Military Governor of Oyo State, 1996, 8 NWLR, Pit 467, 387. Hierarchy within the same court is determined by panel size. Larger panel decisions prevail. Abacha versus Fawehinmi remains the gold standard for the African Charter's domestic enforceability. When the African Charter was domesticated, it became part of Nigerian law with constitutional force. It is not a mere statute, it is a Bill of Rights rooted in both Nigerian and international obligations. By discarding it, the FRN versus Kanu panel did violence to the Constitution itself. No court of law can stand on such a foundation without becoming an engine of oppression. If this perverse precedent is allowed to stand, no Nigerian citizen will have meaningful human rights protections in cases involving state violence. The rule of law will be replaced by the rule of judicial convenience. The Supreme Court's integrity will sink beneath the weight of its own lawlessness. The FRN versus Kanu decision is void for failure to adhere to stare decisis and for arrogating to a 5-man panel the unlawful power to overturn the decision of a 7-man constitutional bench. History will remember this case not as law, but as a monument to judicial betrayal, the day the Supreme Court of Nigeria broke its own oath and buried the African Charter alongside the Constitution, he submitted. The lawyer appealed to the federal government to adhere to the judgment of the Court of Appeal in Abuja, which effectively voided the trial of Kanu, discharged and acquitted him on breach of his fundamental rights. He specifically pleaded that the judgment be invoked by government to terminate the trial and allow the IPOB leader enjoy his deserved freedom.